Right, let's conclude our discussion on the Shankari Prasad case by looking at its negative impact. The one tragic impact because of the Shankari Prasad decision was the license given to the government to keep on inserting anything they wanted to, anything they wished to, into the ninth schedule, resulting in the ballooning of that ninth schedule. It reached epic proportions during the emergency and then kept on increasing after that as well. That is the one negative impact. There were positive ramifications as well. For example, the social reforms carried out by the reservation policy, that was definitely something which has increased the participation of all classes of people in our government and in our education system. But there were negative impacts galore, most importantly being the ninth schedule. So let's take a look at that for a little bit, recalling once again that we are only discussing the history of the Supreme Court over here on our channel. We are not going to talk about the overall history of the Constitution or of India's polity. No, that is not the history. We are only looking at the chronological history of the Supreme Court and its judgment. So we will restrict ourselves to what ended up happening and what was done about it later on, and could it have all been avoided. We have discussed in the previous video, one of the previous videos, which was really a rant about was the First Amendment really necessary, more focusing on was the ninth schedule really necessary, because it did appear even then that the ninth schedule was simply inserted as a means of circumventing the second clause of Article 13, which states that the state shall not make any law which takes away or abridges the fundamental rights, and any law made in contravention of this clause shall be void to the extent of the contravention. That is Article 13 Clause 2. Parliament or state legislatures cannot make any enactment, or the state executive or the union executive cannot make any regulations or perform any executive action which violates the fundamental rights, any of the fundamental rights. That was a crucial part of our liberal constitution, and that was thrown away by the insertion of Article 31B. No provision of any law listed in the ninth schedule shall be deemed to be void or ever to have become void on the ground that it is inconsistent with or abridges the fundamental rights by any provisions in part 3, that is Article 31B. And the Supreme Court in its early days, where it believed that the government was indeed keen on upholding the constitution, gave a very limited reading to the to Article 368 about ratification of the amendment, and it said that this article, insertion of this article, was not actually making any negative changes to the jurisdiction of the higher judiciary. In the words of Justice Patanjali Shastri, who gave the opinion for the Supreme Court, the amendment does not make any changes to the jurisdiction of the higher judiciary. It merely excludes a certain class of cases from the purview of Part 3. That is what was believed. One might say that is what was hoped by the Supreme Court at that time, that Article 31B has been inserted, along with it ninth schedule has been added to the constitution, and what will be listed in the ninth schedule? Only a certain class of cases, that is the laws made by the various state legislatures that deal with zamindari abolition or overall land reforms or land acquisition for public purposes. Only such enactments are going to be added to the ninth schedule, and therefore that does not amount to the reduction in the jurisdiction of the higher judiciary. That is what was believed, and that certainly was the case with the first 13 laws that were added in the ninth schedule along with the First Amendment. We can see they are all either Land Reforms Act or Watan Abolition Act or Land Tenure Abolition Act, Talukdari Abolition. All of these things were quite clearly dealing with land reforms and the abolition of zamindari and other such similar constructs that existed. But immediately after that, the next time the ninth schedule was modified, and by modified we almost always mean added to, That was by the 4th Amendment, which added 7 further laws to the 9th schedule. And let's look at some of the laws. Number 14 to 20 were the items added to the 9th schedule by the 7th Amendment. And look at item number 17, the Insurance Act 1938. Item 18, Railway Companies Emergency Provisions Act. Number 19, Industries Development and Regulation Act. These are not at all quite clearly enactments dealing with zamindari abolition or land reforms or land sealing. None of these things are being dealt with by the Railway Companies Act or by the Insurance Act. Quite clearly, these are no longer restricted to the certain class of cases that was hoped for by the Supreme Court. And then you can see that the number of enactments added just keeps on going up. There are 44 laws added to the 9th schedule by the 17th Amendment. Just 2 by the 29th Amendment, ran out of steam perhaps. 20 more by the 34th Amendment. 38 laws added by the 39th Amendment. This was during the emergency. 64 laws by the 40th Amendment, once again during the emergency. And it's not that just during the emergency this ballooning kept on happening. Look at the next few as well. 47th Amendment, 66th Amendment, all of these were post-emergency amendments. And the number of laws added to the 9th schedule, the number of laws which were basically allowed to infringe and wash away our fundamental rights, that just kept on increasing. Of course, there were not just additions, there were also substitutions. When the Monopolies and Restrictive Trade Practices Act of 1969 was replaced and repealed by the Competitions Act 2002, the corresponding entry in the 9th schedule was modified. The Foreign Exchange Regulation Act 1973 was replaced and repealed by the Foreign Exchange Management Act of 1999. Once again, the corresponding entry in the 9th schedule was changed accordingly. But we have to ask once again, what does the MRTP or FERA have to do with land reforms or zamindari abolition at all in the first place? Why does that matter at all? Things got even more drastic during the emergency, and there have been repeals, there have been omissions from the 9th schedule as well, specifically these 3 items which were removed by the 44th Amendment, one of those gutsy amendments that happened right after the first elections took place after the emergency, and the coalition Janata government under Morarji Desai came into power. They succeeded in omitting at least 3 of those. They specifically omitted the 87th entry, Representation of the People Act 1951, which was also added to the 9th schedule. This is the act under which elections are held. Further, an amendment which was added during the emergency, all of those were all added to the entry number 87 by the 40th Amendment. All of them were removed by the 44th. Number 92, the notorious Maintenance of Internal Security Act 1971 or MISA, after which Lalu Prasad Yadav, one of the politicians arrested during the emergency, his daughter was born while he was in prison, and so they named her MISA after this enactment, after this notorious enactment, a very sarcastic, typical measure by that politician. Even MISA was in the 9th schedule. Once again, not something that had anything to do with land reforms or zamindari abolition. Similarly, look at entry number 130, Prevention of Publication of Objectionable Matter Act 1976, another of those ridiculous emergency measures which had been added to our favorite 9th schedule. The entries just kept on going up, and fortunately at least 3 of the worst ones have been omitted, but the number, you just keep on scrolling and it just keeps on going on and on. And as I have pointed out a few examples, not all of them are land reform legislations, although quite a few are. Admittedly, most of them do deal with zamindari abolition or land reforms or land sealing or something like that. But as soon as the power grab was made possible by the Supreme Court as soon as it allowed the First Amendment to stand, although it was quite clearly taking away the jurisdiction of the higher judiciary. As soon as that power grab had been made, the executive just kept on adding to it. I'm going to list one more example, which for some reason, which I have no idea why, is named 257A. It could have been 258, but it was not. It was named 257A, and that is the Tamil Nadu backward classes, scheduled castes and scheduled tribes reservation of seats in educational institutions and of appointments or posts in the services under the State Act 1993. That is just the name of the act. You can imagine the rest of the number of lines and pages that that enactment might take up. So quite clearly, even reservations made their entry into the 9th schedule, something that was not foreseen at all by this bench, which was basically not prophetic, not prescient in understanding the extent of the impact that this amendment was going to have. Not the best legacy that they were able to leave behind, but many of them did manage to curb the worst of the tendencies of the executive. Unfortunately for us, this is our last discussion, which features Chief Justice Hiralal Kanya, who passed away in November 1951, a month after the Shankari Prasad case. Quick look at Chief Justice Kanya's judicial career. He was elevated from the Bombay High Court to the Federal Court in June 1946. He became the Chief Justice of the Federal Court in August 1947, the day before we gained independence, when the Chief Justice Sir William Patrick Spence chose to resign and ensure that an Indian was in charge of India's highest court. Of course, the Federal Court was succeeded by the Supreme Court of India on the 26th of January, not August 1950. And then Chief Justice Kanya, of course, suffered a tragic heart attack on the 6th of November 1951, passing away 4 years before his retirement was due. He shuffled off this mortal coil, becoming the first Chief Justice to also die in office. So that concludes our discussion on the Shankari Prasad case. In the next video, we will look at the next landmark milestone judgment given by the Supreme Court of India. Hope you will join me then. Bye-bye.